Good morning, everyone. So I am going to be covering a bit of an update. It's not much of an update, but it's a little bit of an update in the estate of Travis Flores against Freedman and Freedman's firm. So Freedman has filed a answer to Clemenciori's complaint. Clemenciori is Travis Flores' spouse, and he is bringing this action on behalf of himself as an individual and the estate of Travis Flores. Okay, so I mean, these are really, really brief things. So we're looking at affirmative defenses. So the first affirmative defense is a failure to state a cause of action. And Freedman is saying basically the complaint and each and every cause of action alleged against defendants therein fails to state facts sufficient to constitute any cause of action against defendants. The second affirmative defense is consent. So the complaint and each and every cause of action against defendants therein is barred by reason of plaintiff's consent. Third affirmative defense, insufficient evidence. The complaint and each and every cause of action alleged against defendants have insufficient evidence to constitute the causes of action alleged in the complaint. Fourth affirmative defense is the statute of limitations. The complaint and each and every cause of action alleged against defendants therein is barred by the applicable statutes of limitations, including without limitation the provisions of California Code of Civil Procedures, sections 337, 340, 340.6, 343, 340.6. I think they put 340.6 twice. I don't know if there's a reason they've done that or not, or if it's just a duplicate. The fifth affirmative defense is waiver. The complaint and each and every cause of action alleged against defendants therein is barred by the doctrine of waiver. And what that means is that Freedman is alleging that there is the intentional relinquishment of a known right. Now, what that may be referring to, and again, it's not specific, so I don't know, but if I had to sort of guess what that's referring to, it's the fact that Travis Flores voluntarily withdrew his case against Wayfarer. So on that basis, there was no misconduct. He wasn't pressured to settle or withdraw the case at all, which is kind of what's been alleged. But I think that means that through the actions of Travis Flores, in regards to the first lawsuit when Travis Flores was alive, Travis Flores' own decisions and conduct basically formed intentional relinquishment. Sixth affirmative defense, estoppel. So, what does that mean then? What it basically means is it's known as the doctrine of estoppel, and it prevents a party from contradicting their previous statements or conduct when another party has reasonably relied on those actions, ensuring fairness in legal proceedings. Again, that could be, Travis Flores voluntarily deciding to dismiss his claim. I don't know, because it is kind of hard. It's not specific about, what part or what cause of action it's referring to. So, it's quite a broad. These are all broad defenses. The seventh affirmative defense, unclean hands. The sixth, just to finish, the complaint in each and every cause of action alleged against defendants is therein barred by the doctrine of estoppel. The seventh is unclean hands. The complaint and each and every cause of action alleged against defendants therein is barred by reason of plaintiff's unclean hands. The eighth, so the eighth is latches. And what that means is it's an equitable defence. It prevents a party from asserting a claim due to an unreasonable delay that prejudices the opposing party. Trying to think of an example. Okay, I suppose if you in the UK, if someone is, say, squatting for 12 years, and you know, as an owner of the property that this person is squatting in, if you do not assert a claim and that 12 years passes, you cannot then come and claim your property. The property will transfer to the squatter's rights. You are given a very long time. 12 years is quite substantial. If you are, you know, not tending and caring to your property and maintaining it, you have not visited it in 12 years and started a legal process to reclaim your property, then you are barred from doing so. And that's kind of an example of how latches would apply, really, is, you know, that is an unreasonable delay. I'm not sure what Freedman is kind of applying that to. I'd have to go through the entire complaint. I don't remember it all off the top of my head, but again, these are just kind of broad defenses. So the complaint and each and every cause of action alleged against defendants therein is barred by the doctrine of latches. Ninth, affirmative defense, failure to mitigate. So obviously mitigation is taking action to reduce harm or reduce burden, reduce costs, etc. Mitigate your losses is probably where it's most commonly heard. So like Blake Lively is claiming damages, but if she's offered jobs and she should be accepting the jobs because she has to mitigate her loss of earnings, for instance. Plaintiff has failed to exercise reasonable care and diligence to mitigate his alleged claims and damages, and therefore plaintiff is barred from any and all recovery sought herein as against defendants. So the 10th defense, excuse. The acts and or omissions of plaintiff excused any act or alleged failure to act on the part of the defendants. 11th affirmative defense, discharge. If defendants had any alleged obligations or legal duties, defendants have appropriately, completely, and fully performed and discharged any alleged obligations and any alleged legal duties arising out of the matters alleged in the complaint. I think that's largely going to be, look, we were paid to represent Travis Flores, 5 years ago, more than 5 years ago, in this case against Justin Baldoni, Wayfarer, and others. We settled the claim, everything was done. That was the end of it. We've discharged our obligations and legal duties. I mean, there could be other things that attaches to, but that's kind of the one that comes to my head. The 12th affirmative defense is superseding intervening clause. Any damages and injuries allegedly incurred by plaintiff are the result of superseding or intervening causes beyond the control of defendants. I think where that's going to apply is because they're saying, so Travis Flores' widow is kind of saying Brian Freedman has spoken out on the case because Brian Freedman was asked about it early on in the current Lively Wayfarer case. He was asked about Travis Flores, and all he said is, look, during that case, he came to understand what an honourable person Justin Baldoni was. And the case was settled without any liability. That is all true. There's nothing untrue about that. It's also not given away anything that would not be already public knowledge. What Travis Flores's husband is he's claiming things like, privacy. He's claiming defamation. And I think what this means is look, at the end of the day, any damages or injuries are kind of not the result of us. And what that is pointing to is the fact that the information that was shared with the newspaper who spoke to Brian Freedman, well, the information that was shared was it was public. But also the fact that the case was that he was questioned about his role in the Travis Flores case came about as a result of this lively lawsuit, and he's saying, well, that's kind of out of our control. I think that what could be what it is. It could be attaching to multiple things. 13th affirmative case defense, offset set off. To the extent defendants are liable for any damages to plaintiff, defendants are entitled to an offset or a set off against any such damages under the common law and under California Code of Civil Procedure 431.70. 14th affirmative offence, no damage. To the extent defendants breached any alleged obligations or legal duties which defendants hereby deny, plaintiff has not been damaged in any amount whatsoever. So he's saying, Clement Ziori has not suffered any damage, which I can see. I can see that. I can't understand what his damages are. Even if the claim, even if the complaint was valid, even if, he could say, look, actually, Brian Freedman, he violated the privacy of, Travis Flores, or he defamed Travis Flores. I can't see what the damage is to Clement Ziori. I just can't see it. Travis Flores passed away, sadly, a few years ago. So what is the damage here? And what damage specifically has been accrued that would not have already been accrued, at the time the original lawsuit was dealt with? Plaintiff has not been damaged in any amount whatsoever and is not entitled to any general compensatory or other damages or any other relief as a result of any such breach. 15th defense, good faith. The complaint and each and every cause of action stated therein is barred because defendants' alleged actions were formed in good faith. 17th, actions of others. The damages and injuries, if any, suffered by plaintiff were directly and proximately caused solely by the careless, reckless, negligent, and wrongful conduct of individuals or entities other than defendants. As a consequence thereof, the defendant is barred from recovery herein. 17th, due process bars punitive damages. The complaint fails to state facts sufficient to permit an award of punitive damages, and any such award would violate due process. Any award of punitive damages would violate defendants' rights under the 1st, 5th, 8th, and 14th Amendments to the United States Constitution and Article 1, Sections 7, 16, and 17 of the California Constitution. 18th, defense. No exemplary damages. The complaint and each and every cause of action stated therein fails to state any facts supporting any claim for punitive or exemplary damages. 19th, affirmative defense, no malice. That would obviously go to the defamation claim. The complaint and each and every cause of action stated therein is barred in whole or in part because at all material times defendants acted in good faith and without malice based upon all relevant facts and circumstances known by defendants at the time. Would Travis Flores be considered a public figure who would require would require the bar have the added bar of actual malice? I think so, possibly, yes, because he was a very well-known activist for cystic fibrosis. He had been on, it is part of documentaries, and he has a public persona. He's also a screenwriter, so yeah, I think he hits that mark. 20th, affirmative defense, insufficient evidence. The complaint and each and every cause of action alleged against defendants have insufficient evidence to constitute the causes of actions alleged in the complaint. The 21st, affirmative defense, contributory negligence. Any injury or damage to plaintiff which defendants deny was proximately caused in whole or in part by the negligence of plaintiff. 22nd, affirmative defense, no actual injury. Plaintiff has suffered no actual injury from any of the causes of the action alleged. The 23rd, affirmative defense, this doesn't go on much longer, thankfully. Public interest or concern. The complaint and any cause of action alleged therein based on defendant's speech or alleged speech are barred as the alleged speech at issue in the complaint relates to matters of public interest or concern, and plaintiff has not suffered any actual injury and or defendants did not act with constitutional or malice. The 24th, affirmative defense, the freedom of speech. So the complaint and any cause of action alleged therein based on alleged defamation or injurious falsehoods are barred as any alleged conduct, act, or omission on the part of defendants was protected under the 1st and 14th Amendments to the United States Constitution, as well as Article 1, Section 2 of the California Constitution, and any and all other laws designed to protect freedom of speech. The 25th, affirmative defense, mistake / lack of intent. The complaint and any cause of action alleged therein are barred by unilateral or mutual mistake. Plaintiff's damages, if any, were unintentional and occurred without any negligence, want of care, default, or other breach of duty on the part of defendants. 26th, affirmative defense, comparative fault. If plaintiff incurred any injury or damage which defendants specifically deny, such injury or damage was proximately caused by the negligence, recklessness, or intentional conduct of others who acted as plaintiff's agent, legal counsel, or representative. Accordingly, if any liability is found on the part of defendants, then such liability to plaintiff must be reduced on the basis of comparative fault. 27th, affirmative defense, assumption of risk. Let's have a look at that. Assumption of risk. Yeah. Plaintiff, his agents, servants, and employees knowingly and willingly assumed the risk of injury and damages with regard to the matters alleged in the complaint. Said knowing and willful assumption of the risk directly and proximately caused and contributed to plaintiff's alleged injuries and damages, if any, and as a consequence thereof, plaintiff is barred from recovery herein. 28th, affirmative defense, truth / substantial truth. The complaint and any cause of action alleged herein based on alleged defamation or injurious falsehoods are barred as the alleged statements in the complaint were true or substantially true and / or were not false statements of fact. 29th, affirmative defense, public figure or limited public figure. The complaint and any cause of action alleged therein based on alleged defamation or injurious falsehoods are barred because the individuals about which the alleged statements were made were public figures, or at least a limited purpose public figure. And I think Travis Flores might fit into the limited purpose public figure. And defendants did not make any alleged defamatory statements with constitutional or actual malice. 30th, affirmative defense. Lack of standing. The complaint and each of its causes of actions are barred in whole or in part due to plaintiff's lack of standing. The 31st, affirmative defense. Lack of particularity. The breach of fiduciary duty cause of action is not pled with the required specificity and particularity and therefore cannot be maintained against defendants. 32nd, affirmative defense, Civil Code, Section 47. Plaintiff's complaint is barred in whole or in part by California Civil Code 47. And then the last one, 33rd, affirmative defense, reservation. Defendants presently have insufficient knowledge or information on which to form a belief as to whether they may have additional as yet unstated affirmative defenses available. Defendants reserve the right to assert additional defenses in the event that discovery indicates they would be appropriate. Okay, so what are they asking for? Wherefore, having fully answered this complaint, answering defendants respectfully hereby request that this court enter judgment as follows. That plaintiff takes nothing by reason of his complaint, dismissing the complaint in its entirety with prejudice, awarding costs and attorney's fees in favour of defendants, and granting such other further and different relief as to this court deems just and equitable and proper under the circumstances. Okay, so that's as quick as possible anyway, a run through of the answers, because they've answered the complaint. The motion to strike is still pending. But we do have some orders. So, where is... Let me just find the complaint. Progress. Okay, so the original complaint, who is this? Trying to think. There was a yeah, that's it. Sorry. Right, I've got it now. Right, so the original, if I bring up Freedman's anti-slap from earlier last month. Earlier last month it was. Right, at the time, the case was assigned to Judge Brock T. Hammond. And Freedman filed a request for recusal under Civil Code of Procedure, Section 170.6. He wanted basically the judge to recuse himself and be replaced, citing that he did not believe that he would have a fair and impartial trial or hearing before this particular judge. So what we can see now, right, from this order is that judge has recused himself, and it is now being signed to Judge Nicholas F. Daum. I hope I'm saying that right. But we have a few things going on. So on March the 5th, 2026, at 9 a.m., we have a hearing date on the anti-slap motion. So I'm obviously not going to be there, but as soon as we get an order or something on it, I will do a video to say what's going to happen there. The There's also a case management conference scheduled for March 17th. That can't be right. It cannot be in 2029. Surely that is a misprint. We'll find out. I'm not going to go through all of this though. But yeah, it is a misprint because here is that date and it is 2026. Phew, I did not want to be covering this for another 3 years. But yeah, so we got some hearings in the pipeline as well. I haven't looked through this, so we can just have a look. Nature of proceedings, court order. Okay. Yeah, so this is just kind of confirming that the civil procedure, Code of Civil Procedure filing for the to challenge the judicial officer, i.e. the previous judge, under section 170.6 was timely filed, proper format, and is accepted. So they have now, this is confirming that the case is now reassigned to Judge Nicholas F. Down. In theory, Travis Flores' widow, I believe, could file his own notice of judicial challenge against this judge. I'm not sure if he will or not, but in theory, he could. Okay, so these are just really notices of hearings. There's going to be a hearing on a special motion to strike and the anti-SLAPP. That is going to be, it was previously set for the 6th of May actually, but it has now been changed to, this says the 17th of March, but I thought that was God. Yeah, this one says March 5th for the anti-SLAPP motion. And it's a case management that's on the 17th. I'm confused by this order. Okay, just to make sure I'm not going completely crazy here. The new hearing date on the anti-SLAPP motion, so the top one of these two, is March 5th, 2026. And the case management conference date, which is not the same thing, is March 17th. And we know that's 2026 and not 2029. But this order says that the hearing on the special motion to strike, i.e. the anti-SLAPP, is on the 17th, which is supposed to be the date of the conference, the case management. Oh, God. I'm so confused. Yeah, see, this says the case management I need to go and get myself a new clerk. Yeah, so this is this is frustrating to see this kind of crap. Okay, so I'm not quite sure what is going on with that. At the top, the cover sheet clearly says that the hearing is going to be on March the 5th. Sorry, I know I'm bouncing around a bit and I don't mean to, but I'm trying to work out what is going on with this inconsistency. So it says the new hearing date on the anti-SLAPP motion is March 5th. And the new case management conference is March 17th. But this order on the hearing for the motion to strike, for some reason, has the date for the conference, case management conference instead And that can't be right because that is at 9 o'clock on the 17th of March, if we're to believe this. But at the same time, they're having something completely different. What is what? I will just keep my eye out, I think, and see if something clarifies this. Um, but yeah, okay. So that's kind of the update. Is Freedman has filed an answer to Glamanziori's complaint. The judge, the request for the challenge to the judicial officer was accepted, and the case has now been reassigned to a different judge. And there is supposed to be a hearing. There's definitely going to be something going on the 17th of March, but it's confusing about what is happening with the anti-SLAPP motion hearing. So I will see what I can glean and then let you guys know, and just keep an eye out for any filings to update us on that. All right, guys, thank you. Take care.